disabilities, they remain extremely disadvantaged. And may I remind you that disability is the only designated status that all of us can acquire. Tomorrow we can wake up being called persons with disability. It is definitely an area that we should be looking at, and we should be looking at how we advance the cause of persons with disability. Without wasting too much time, Minister, I'm going to go on then and talk to the amendments which have become such a hot potato in our country at the moment. And I'm seeking, by doing this, to demystify and debunk a lot of the misconceptions that have been created and the narratives that are being shared around the amendments that have been put in place. Let's just talk very quickly about the three key objectives of the amendments. There are three. The first one is to remove the regulatory burden on smaller employers. So we have said that any employer who has less than 49 employees would no longer, according to the Amendment Act, be considered a designated employer. And I will share with you what it means at a practical level in terms of compliance to the law. Secondly, the Act empowers the Minister to regulate sector-specific EE numerical targets. And without going into too much detail, I want to remind all of us that based on sector engagements that we had in 2017 with captains of industries and transformation, Section 21 managers, they have said to us, go ahead and implement sector targets. So it is informed by what people have said to us. We've taken what they've given us because indeed we are a democratic country. We've taken what we've heard from the people who deal with this on a daily basis, and we've said, how do we practicalize it? And thus we've come up with the Amendment Act in order to empower the Minister to put in place EE-specific targets. Now I need to say at this point, as I debunk the myths, that the representativity that we're seeking, Minister, is representativity for suitably qualified people in the designated groups. We are not asking any employer to appoint a person who is not qualified for a role or who doesn't even demonstrate any potential to be able to take on that role with much success. So we're empowering the Minister to give these five-year sector targets. And we're saying, Minister, so far self-regulation has not worked for us. There's been hardly any change. And as a country, our people are getting impatient and they want change. Therefore, we are empowering the Minister with the advice from the Commission and with consultation from employers in the different sectors. I will emphasize, we've come up with these sector targets. Thirdly, we want to promulgate Section 53 of the EEA, and with it, we're going to enable the Minister to issue out employment equity compliance certificates that will enable employers to do business with organs of state and state-owned enterprises. So those are the three key reasons why we've put the Amendment Act in place. Now, I said I'll discuss the difference in definition from a designated and a non-designated employer. Non-designated employers, as I defined it, are employers who have 49 and less employees. Now, this is their obligation in terms of the Employment Equity Act. They will be expected still to comply with the national minimum wage, except in cases where they've been granted exemption from that. And when we look at their compliance, we'll look at the previous 12 months in terms of how they've paid their employees. We're also saying those employers should also not have any unfair discrimination awards against them if they want a certificate of compliance. And this certificate of compliance, if I can remind you, will enable them to do business with government. So whilst they may not necessarily have to follow all the compliance steps that designated employers will have to follow, this enables them to do business with government. Now, coming to designated employers, which are employers that have 50 or more employees, these are the criteria for compliance. The first, they will need to submit an annual EE report, that is the EEA2, as well as the EEA4 form, in line with the prescripts of the law. They will also need to work progressively towards achieving the 5-year sector targets that we have put in the regulations and are now busy with the comments that we've received. Thirdly, they will need to comply with the national minimum wage. And again, in this case, we're saying in cases where they've got an exemption, they would not be expected to do that. And finally, they would not get a certificate if they have any award from the Labour Court or from the CCMA of unfair discrimination. Remember that the Employment Equity Act is not only about affirmative action, but it also looks at substantive equality. And the only measure we have at this stage to say whether an employer is compliant to the law in terms of substantive equality is the extent to which disputes are declared at the CCMA or at the Labour Court. So this will be the criteria of getting the Section 53 certificate. Now, we want to deal with the issue that we are hearing, the noise that we're hearing around sector targets being quotas. Let's first define what a quota is. First, a quota is rigid. It doesn't have any flexibility within it. It says, these are the targets and you will comply with them come hell or high water. And that is not the case. If you read our regulations, you will see that that is not the intent or the spirit of the Act as we have put it. Secondly, these are targets, and we say they're flexible for two main reasons. The first is that the employer still has the power to consult with employees and to self-regulate on an annual basis how they work towards achieving the 5-year sector targets. So within the 5-year period, once we've put the sector targets out there, within the 5-year period is the flexibility of an employer to see how they work with milestones towards achieving what they need to achieve in consultation with their employers. Secondly, in seeking to achieve their targets, we will also allow employers, where they cannot, to give what we call justifiable reasons why they have not been able to meet the sector targets or even the annual goals that they've set for themselves. Let's talk about the justifiable reasons, and at this point I need to indicate that these justifiable reasons were discussed and agreed upon at NEDLEC. We went through a process of unpacking all the possible reasons why an employer might not be able to achieve sector targets and why we would not withhold a sector compliance certificate if these reasons are given as justifiable and valid. In cases where there are insufficient recruitment opportunities, obviously, an employer cannot then bring designated employees into the organization because opportunities are not there. Vacant positions do not exist. So that would form a justifiable reason. Insufficient promotion opportunities, insufficient targeted individuals from designated groups where the skills pool is not sufficient or does not provide the skills that are required for that particular organization. Where, for some reason or other, there is a court order or a CCMA finding that says you shall not appoint, or whatever the reason may be that may make it difficult for an employer to put in place those sector targets. In cases where there's transfer of business, we recognize that there are certain logistical issues that would make it difficult to achieve the sector targets, as well as mergers and acquisitions. And finally, the impact of circumstances. It could be business circumstances, it could be political climate, it could be any other reason that employers are able to give, such as load shedding, on the achievement of sector targets. So these are the reasons, and we do believe that these reasons then enable us to say without a doubt, without flinching, that the sector targets that we are putting in place are definitely not quotas. Now, the process of consultation that we embarked on in arriving at the sector targets is a process that took over 3 years. We didn't just wake up one day and said, these are the sector targets that we're putting, and, how can we do it? Like we've been accused of playing on calculators and making decisions. No. Totally well thought through process and a negotiated process. So we looked at the national and provincial EAP as provided to us by Stats SA, and in this case we focused on quarter Q3 of 2022 to arrive at the sector targets. We also went ahead and used the sector charters as well as the sector codes that are linked to the BEE Act. And this was quite interesting because in most sectors where we went in and we said, we're going to set the sector target based on what you already have on your BEE charter. A lot of the sectors were like, no, you cannot use that. You cannot use that. We don't really, we think it's too high. We don't believe in it. It was not scientific. And we were like, okay, so how did we get here? And it took us a process of consultation and going back and forth, listening to the inputs that we received from the different sectors to arrive at these targets. We also looked at the 2022 EE workforce profile status and used that as benchmark in setting the targets. And then we also considered the unique sector dynamics in order for us to say what would be reasonable per sector in arriving at these. So it's a well thought out process. It's a consultative process. It's not a process that is like people argue the minister is being given undue power. It's a process that is well thought through, and there was a consultation around it. Now, one of the queries and questions that we've been asked once we put out the regulations for public comment was issues such as, well, when we look at what you've given us as the total for the 5-year sector, you've said 60% designated employees should be received. And then now how do we get to the 100% that we're looking for? And we are saying, remember, we're not asking you to work on the EAP. We're saying, but within the 5-year period, use this as a benchmark based on where you are. And remember, at the end of the day, it will give, we are working on only 92% of the population that is there. We are excluding foreign nationals and we are excluding the white population, which is only 8% of the EAP. Now, due to overrepresentation of the white population, it makes sense that we will not set targets for these for the white population in the top 4 levels of the labor market. We also want to emphasize that we are in no way expecting any employer to dismiss anyone for EE purposes. That would be not in compliance to the Act or the ILO prescripts. When an employer talks about opportunities for employment equity, it is based on natural attrition and availability of opportunities, and thus the justifiable reasons that I've shared with you in the beginning. We are in no way asking any employer to dismiss people just to meet the EE requirements. Now, when we look at this, it's important also to remember that we're not only looking at the national EAP. Depending on where an organization is, we are saying that it may make sense to look at regional EAP, and we allow that. So what is the process that an employer would follow? Establish the most current workforce profile at the workplace and select the correct EAP that fits the organization's operations. So if you're in the Western Cape, of course you would look at the regional EAP in looking at how you set your targets. You would also select the core sector that you belong to. You would use both the EAP, be it regional or national, as well as the sector targets to plan. And this would not only include race, it would include gender and disability, and we've set targets for those. Where there's underrepresentation in terms of the 5-year sector targets, Numerical annual targets would then be set, and these need to be worked at as a progressive milestone in order to get to that. And yes, where employers have exceeded the 5-year sector targets, we then expect them to chase the EAP. We're not saying because now you've gone beyond the sector target, now you must now relax and not have anything to work towards. Yes, there's an EAP. Remember, that is the ultimate goal of the Employment Equity Act. So employers who have already exceeded the sector targets would then continue to set their annual targets based on their respective EAPs. Way forward, you will remember that we published on Friday, the 12th of May 2023, our regulations, sector target regulations for public comments for 30 days, which closed on the 11th of June. We've received quite a lot. Upon proclamation of the implementation date, the effective date of the EEA amendment and the regulations, we will then publish the full regulations around implementation, and then when the next reporting cycle comes into place, employers would then have to comply with the Amendment Act. As a commission and as the department, we will embark on national EE awareness campaigns where we debunk some of the myths and we answer questions where there is uncertainty. This will commence mid-July. We might move it forward, but mid-July was the date that we'd set.